Today's workshop is It's Your Rights, What Family Caregivers Should Know About the New Medicaid Rules for Adult Developmental Services. I'm excited to introduce you to Kirsten Murphy, Executive Director of the Vermont Developmental Disabilities Council, where she has worked since 2013. She began her career in nonprofit management in the 80s, developing programs for high-risk youth in New York City and Boston. Her interest turned to disability rights and community inclusion when two of her children were diagnosed on the autism spectrum. Kirsten founded a family support program, ARCH, serving the Upper Valley region of New Hampshire and Vermont, directed the New Hampshire Autism Council, and is credited with securing equitable insurance coverage for New Hampshire children who experience the interfering symptoms of autism. She is a 2010 graduate of the Leadership in Neurodevelopmental Disabilities program, LEND, through the University of New Hampshire. Now a resident of Montpelier, Vermont, she brings over 3 decades of experience in public policy, systems thinking, and advocacy. Thank you so much for joining us today.
Thanks so much, Karen. And thank you to Vermont Family Network for letting me provide this information to family caregivers. It's really a part of a series of conversations I've been trying to have with families and self-advocates and providers as well about a bundle of rules that came out back in 2014. Can we go to the next slide? So this is just an overview of what I'll talk about today. I'll explain a little bit about how we got here, and that involves my touching a little bit on sort of a Medicaid 101 and some overview of how Medicaid has evolved. Then we're going to really drill down and look at a piece of the settings rule. So as I said, this is a bundle of different talks. You may have seen a previous talk I gave about case management. I'll be giving one about person-centered planning later in the year. But right now we're going to focus down on how these 2014 rules impact the individual and their service agreement in sort of terms of where they can live and what they can do in their setting. And this is appropriate for caregivers of adults, but also for anybody that's wondering about adult services because they have a transition age person in their life that they're supporting. And then I will finally talk about where you can find some more information, since the state has finally posted some guidelines around these issues. Next slide, please. So first, I'm just going to do a little bit of background. Next slide. You'll hear me talk a lot about CMS. So just to be clear, that's the Center for Medicaid and Medicare Services. It is the federal Medicaid authority. And just to level set, 3 facts that I call Medicaid 101. So Medicaid comes in 2 flavors, if you will. You may be familiar with it as health insurance, right? That's sometimes called state plan Medicaid. The other bundle of services is different from health insurance. It's the form of Medicaid that supports long-term services and supports, or sometimes more commonly known in Vermont as home and community-based services. So you'll see it abbreviated as HCBS, right? And that's about 22% of what Vermont spends on in its Medicaid budget is for those home and community-based services, which are something that regular insurance just doesn't cover. Medicaid is a sprawling program. It has been historically a way the United States government has strengthened the safety net for vulnerable populations, often when it didn't think that it could get a more specific piece of legislation through Congress. It would kind of backfill services into this Medicaid program. So it has become this huge $644 billion program. Next slide. Second fact about Medicaid is that it is a federal and state partnership. So it is important to remember that about half of Medicaid spending comes from the federal government. And it's governed by a contract. And Vermont is unusual in that it only has one contract with CMS, and that's called global commitment. So if you hear that term, you're like, what is global commitment? And you think it's just health insurance? It's actually about all Medicaid spending for the state of Vermont. Next slide. Here's the important thing to be aware of. I say it this way. The feds set the floor and the states raise the roof. So like all federal programs, the federal rules are the absolute bare minimum. Like you can't do less than the federal rules. So sometimes Vermont is like seeing these federal rules coming down through CMS, through Medicaid. And they've gone, those don't really apply to us, or we don't have to do that. The federal rules trump state rules, and they set the absolute bottom. And then states can exceed and do more, and often do. Vermont covers more people through Medicaid than it absolutely has to, but you can't do less than what the federal rules say. So if we could turn to the next slide, this is just a quick timeline because I want to give you a sense of how long the trajectory has been to get us here. So we passed it's a 43-year history. We passed the Americans with Disabilities Act back in 1990, which allowed everyone some, basic rights. And you see that big red star. 3 years later, Vermont closed its state institution for people with intellectual disabilities, Brandon Training School. Almost more important for our purposes is in 1999, the Supreme Court ruled that it was discriminatory not to provide people an option to live in the community if you could do so safely. And so that was a little bit after. Vermont was already on the way to building community-based supports. We got a Supreme Court ruling in 99. Now, the wheels of the federal government turn so slowly. It's like making an oil tanker get off, change its course by 15 degrees. CMS had never defined what community living meant. And it took them all the way until 2014 to actually begin to spell that out. So these rules came out in 14, and they're very, very important, but they took that's a really long time to figure out what exactly is community living. And then the rule that we're talking about today did not actually come into effect until March 17th, St. Patrick's Day, last year. So this is still new news in some ways, but we have seen it coming since 2014. So just to go to the next slide quickly. This is a little bit of a backtrack, but this is the Olmstead decision versus LC, which is Lois Curtis, the lady on the right. And again, this is where the Supreme Court finally said in a really definitive way, hey, states, if you're going to use public money to support people through the Medicaid program, you're going to have a community-based option. Next slide. But in the absence of the federal government saying what community living needed to look like, state got real fuzzy about what that was, understandably. So some states were using the grounds of, say, a former institution to house people with intellectual and developmental disabilities and calling that community living and billing Medicaid as if that was community living, even though these were still very institutional in nature and pretty segregated. There was a lot of examples all across the country, and Medicaid was saying, the Medicaid authority was like, that wasn't really what we meant by community living. So they engaged in a very lengthy stakeholder process. They talked to literally thousands of people and took public comment very extensively before they published the 2014 rules. Importantly, one of the things that happened is the Administration for Community Living, which is the federal bureaucracy I report to, commissioned a paper that they was informed by a group of self-advocates talking about what community living meant to them. And interestingly, there were Vermonters in that group, but interestingly, the insight from that paper was it's not so much about the building. It's not what the building looks like so much. It's not where the building's located. It's about the quality of services that someone's receiving. And Medicaid took that really seriously. And so when they defined community living, it has a lot to do with the quality of the service, how the service is planned, the nature of individuals' freedoms and rights when they're receiving these type of services. So that's kind of just how we got to this rule, which you might think is a little odd in the way it created a definition for community living. Next page, please. So yeah, we can skip and go to the next one. So let's look at first the general principles. Okay, this is the hardest part of this talk because these are fairly general. There haven't been court cases that I'm aware of anyway, I think I would be, that have sought greater definition. But this is the basic framework that CMS published in 2014 and is now law. Next slide. So again, just to review, these rules are about where someone lives, how someone spends their time, how someone plans for their support, and how those supports are actually delivered. Next slide. So what CMS said is that a setting, and a setting here just means where the person lives, where they receive their home and community-based services. A setting is truly home and community-based when it is integrated and supports access to the greater community. So again, that seems very big and abstract, right? We can kind of say something about what that isn't, right? If someone is living in whatever setting, home provider, group home, whatever, and they only get to go in the community once a month outside of the home that they're living in, that wouldn't cut it. Like, that's not integrated, right? If they live someplace and say their home provider says, you know what, I'm just not going to provide transportation. So if you want to leave, you can walk downtown, but that's it. That's as far as we're going. That would raise red flags, right? But we still have, litigation and negotiation around what this term means, right? A setting is truly home and community-based when it ensures that the individual receives services in the community to the same degree of access as individuals not receiving Medicaid home and community-based services. So here's the standard. The reason going into the community once a month isn't true community access is because if a person didn't have a disability, they would typically be able to go into the community more than once a month. All right, so that's a useful standard. Again, we're moving toward greater understanding. Next slide. A setting is truly home and community-based when it provides opportunities to seek employment, engage in community life, and control personal resources. So one concrete thing that means is that when an individual, regardless of their support needs, has a planning meeting around their services, the agency has to raise the issue of employment. The individual or their team may not decide that that's appropriate or desirable, but it has to at least be on the table, right? There has to be some kind of plan in somebody's service agreement that gets them outside of the actual residence where they're residing with some periodicity. Okay, so some cadence of regular time outside of the residence. And they have to have some control over personal resources. Does that mean they have to run their own bank account? Not necessarily at all, right? It would depend very much on the individual. It might simply mean being in charge of your wardrobe or what personal possessions you have in your bedroom. But some ability to control personal resources is an expectation of anyone receiving these kinds of supports. Next page. A setting is truly home and community-based when it ensures an individual's rights to privacy, dignity, respect, and freedom from coercion and restraint. I think the big news in this one was privacy. So someone asked about roommate situations. I know that was a question that came in to us earlier. When these rules start to get more specific, it is clear that if an individual is going to have a roommate, the individual has to agree to and select that roommate. And if an individual does not want a roommate, they should be able to have an option for personal privacy in their bedroom and the bathroom that they're going to mostly be using. So that wasn't very spelled out previously in the rules, and that's becomes more clear. Dignity and respect, I think, have always been standards of our system. Also, there are clear rules around restraint and seclusion, but they are, again, embedded into the new CMS expectations of what quality HCBS looks like. Next slide. And these are the last big picture comments. A setting is truly home and community based when it is selected by the individual from among setting options. So let's focus on that one for a minute, because many family members who are involved with the Developmental Disability Housing Initiative have really raised the issue of, hey, is it choice if we get offered shared living and that's it? Or one shared living provider and not a range of people? And the CMS rules are pretty clear that that's not giving someone the option of selecting from among settings. And it now has to be documented in somebody's individual service agreement that they were offered more than one choice, including the choice of non-disability specific settings with an option for a private unit. Now that might be living with your parents, right? It might be something still very, with a lot of safety and support around it. But again, there has to be documentation that people were not offered just one option. And this is really I don't want to say that's easy in a system where we are starving for housing options, starving for workers, right? But those are the rules. The setting has to optimize individual initiative, autonomy, and independence in making life choices. Now that recognizes that everyone has different support needs. And for some people, that might mean choosing what you eat for dinner. And for other people, it might mean choosing where you work. But some degree, to the degree it's appropriate, individuals have to be supported in making some meaningful choices for themselves. I would argue that, and this is my opinion, that supports that don't help an individual obtain the communication skills to voice a choice would really be problematic under this rule, because how else are you able to optimize the individual initiative and autonomy? That is my opinion, not the state's opinion necessarily. I think that's the logical outcome of that prescription. And finally, the setting needs to facilitate individual choice regarding the services and supports and who provides them. So if an individual has a very adverse feeling about a provider, that has to be taken seriously, right? Because that individual has to have some choice over who's going to be providing those supports to them. Next slide, please. We're now going to move from the aspirational, because those were really big picture ideas, to more specific rules that apply to what are known as provider-owned and controlled settings. Next slide. So where do these rules apply? What's a provider-owned controlled setting or controlled setting? It's kind of what it says, right? If the agency either contracts for that setting, as in a home provider, or it owns that setting, like a group home, or a staff living situation, the rule applies. So it applies to staff living, as that's defined in our system of care, which is when 1 or 2 people live with full-time staff. It applies to group living, as defined in the system of care, which is when 3 to 6 people live with full-time staff. It applies to shared living. That is not even debatable. Let me be clear about that. Some people would like to maybe have that conversation, but no, it applies to shared living situations. And it applies to supervised living, where 1 or 2 people share a home and they have part-time staff in that home. In other words, there's residential support being provided to them. It does not apply to an individual who's living with an unpaid family member. So if you're living with your parents, this rule doesn't apply to you, these rules. These rules about the provider-owned settings. However, if you live with your aunt and your aunt is being paid as a home provider, the rule does apply. And it also doesn't apply to individuals who have enough independence to be living in their own apartment and they don't happen to have home support in that apartment. They might still have a direct support professional that provides community support, but if they don't have the services that are categorized as home support, then these rules that I'm now going to talk about don't apply. It also doesn't apply in out-of-home respite settings, probably because those are temporary. Next slide. All right, rule number 1. You must have a residency agreement. And that has to provide lease-like is the term protections. So it is not a lease, but it has to have the same degree of protection as the tenant law in your state affords you. So a lot of us thought that if the state of Vermont had 15 different residency agreements, one for each agency, that was going to be a complete nightmare. So we advocated really strongly that the state come up with one template for the residency agreement, which they have in fact done. And it's not finalized yet, but I do have a copy of it, and I'll tell you a little bit more about what's in it. What's the problem CMS is trying to solve here? The problem is people waking up in the morning and all of a sudden their home provider is fed up and says, that's it, you need to be out of here by the end of the week. That's less protection than you would have if you were an actual tenant with a lease. So now there may be reasons someone needs to leave more quickly, very quickly. That's a different matter. But if it's initiated by the provider, next slide, please, you need to get 30 days notice. Still not great, but that's as long as the rules would allow. The reason that you're being asked to move has to be stipulated. The individual has to hear about their appeal rights because they have the same appeal rights that they would have as a tenant. And the agreement has to be signed and explained in plain language as much as possible to the individual prior to their moving into particularly a home, a shared living situation. This would also apply to group homes. So I have seen the draft residency agreement, and it's fairly understandable. I wouldn't say it's there yet. And it's important to know that it does describe the rights and responsibilities of the individual. And I'm emphasizing here the responsibilities. So the individual has to do certain minimum things to not trigger being asked to leave. You have to assure payment for room and board is on time. People often have support to do that, but not an unreasonable expectation. You have to keep your living space clean and safe. You have to notify the home provider if there are problems in your living space, like the toilet is backing up. You do not cause damage to the house or items in the house. You're responsible for your visitors' behavior. We'll talk more about visitors. And you act in a respectful manner that will not disturb others in the residence. Now, some of that might be pretty challenging for some individuals, but it isn't necessarily an unreasonable expectation from the point of view of the home provider. We're trying to kind of come up with a balance here. The agreement also spells out all of the rules that I've gone over and will continue to go over in this talk. So there's a lot of responsibility on the part of the home provider or group home coordinator or agency. So that's the residency agreement. Next slide. Second thing you must have, and this has been very controversial, is this. I remember I said privacy rights are now a big deal. The service recipient must have a lock on their room or similar personal space. So that's not optional. Some people have asked about that. Well, what if the recipient of service doesn't want a lock? They have a right to not use the lock, but there has to be a lock provided. And the state is not mincing words about that. They have specific guidance, I'll show you the link later, that spell out just the specifics around the room lock. They offer different options of types of locks, etc. Clearly, if the person has a roommate, the roommate has to have a key or ability to enter, and the home provider or some other on-site provider needs to have the ability to enter. And just to finish out on the privacy rights, it is actually specifically in the CMS rules, and this is surprisingly specific to me. The individual has the right to decorate their room the way they want. And notice the residency agreement said you have to keep it clean and safe. But if you want to have 27 candles burning, that's probably not going to be okay. But if you want to decorate the walls with posters of I don't know what, sunrises, that's up to you. So you have to have some, again, that's that kind of about having some control over your personal items. Next slide. So a little bit more on the guidance for door locks. If the individual uses one bathroom and it isn't entered from their bedroom, then that bathroom also has to have a lock. You may use the lock to safeguard your possessions when you're not there. But obviously, for safety reasons, the type of lock has to be one that allows you to exit without delay, like a fire or something like that. I know that this is going to raise a lot of interesting questions about safety. I will talk at the end about how you get some of these individual rules waived, because for some people, a lock might be too hard to manage, and then it can be waived. But we'll talk about that in a minute. And I saw something in the chat about housemates. Yes, Barbara, I think you're asking about, does a person have a right to pick housemates? I do not believe that's in the rule, but I'd like to confirm it because I haven't been asked that question before. You have the right to pick people that you share sleeping space with, or to not share a sleeping space with someone. But if you're going into a group home, I'm less sure about what the rules are to pick other people in the group home. I don't think that's assured in the rules, but I will double check. Next slide, please. I'm almost done with these specific rules. So other rules.
Kirsten, yep. Just a time check. It's 11:29. So
thank you so much. So the rules for provider under controlled settings also require accessibility. So that, you have to have a ramp if someone's going to be a wheelchair user. You can't have barriers in the home that restrict the wheelchair user in such a manner that they can only use a small portion of the home, for example. I have seen that happen. If the bathroom has to be accessible. Some of these basic things, these are required under other laws too, but they're now spelled out in the CMS rules. Next slide. You have a right to control your daily schedule. So you have a right to decide how you spend your time, and a provider cannot decide, for example, that it's bedtime at 7 o'clock or even at 10. These are adults, and that's not going to be something the provider can create a house rule about unless it's waived and there's a specific safety reason why that has to happen. We have to be reasonable about this. If what you want to do with your time is completely unrealistic, like, well, I want to go to Cancun this morning, that, it's not what we're talking about here. But if everyone eats breakfast at 9 and you, for some reason, don't want to get up for breakfast, you want your breakfast at 11, you have a right to do that. I know that's not going to sit well with everyone, but that is, in fact, the rule. And we're going to talk more about food in a minute. Next slide. Also, maybe going to feel a little interesting for people. You have a right to have visitors in your setting. So a home, a group home, or where you live with a home provider or staff. You're allowed to have visitors whenever you want. And that, unless that individual has created some kind of specific problem, you get to choose who that is, any friend or family. And it's going to be an interesting conversation, but if you want to have an overnight guest, the rules would seem to imply that that is acceptable. Now, again, there may be situations where you want to have that not happen, and you'd have to go through the service agreement to make that happen. What the rules say. Last slide. So, and then I said I'd talk about food. You have a right to have food at any time, unless there's a health reason. So if you want to have ice cream at 10 o'clock, that might not be really great for you, but you're an adult and you're allowed to have ice cream at 10 o'clock at night. So that's the rule. Next slide. So what about exceptions? Because I'm sure that there are many reasons why individuals would want to have exceptions. So a good example would be somebody with Prader-Willi syndrome who can't safely have access to food 24/7. That would be a very serious risk for that individual. It is completely permissible under the CMS rules to write an exception into the individual service agreement. Some things to know about that, however, it needs to be handled on a case-by-case basis. So you cannot make a rule for the whole group home. Nobody can have access to food after 7 o'clock in this group home. It has to be about each individual. The exception has to be documented in the individual's service plan, and the rule has to be based on a health and safety concern, not the convenience of the provider. So the expectation is that the team writing the ISA will document in some way, probably through the individual's needs assessment, that it's not appropriate for a health or safety reason for them to have X right or freedom in their living space. Next slide. So I want to make sure I have time for Q&A. So what if I do if my rights or my family members' rights are not being honored and I'm concerned about it? You, a family member or an individual with a disability, can bring a complaint, first usually to the service coordinator at your agency. That might not get you very far. You can call the State Division of Developmental Services, and you can call Vermont Legal Aid. Now, in the future, because we will be moving to independent case management, a logical place to bring these concerns is your independent case manager. And then finally, you can soon be able to access the services of an independent advocate for the, well, this is going to be specific to brain injury and to developmental disabilities. It's being called the BDAP program. People in the Choices for Care program have had an ombudsman for many, many years. And a lot of us have argued for a long time that you should have an equivalent independent advocate in developmental disability services. So Vermont Legal Aid is starting to stand that project up. And it's actually a great place to resolve smaller complaints. I mean, there's mechanisms for abuse and neglect, but if you really want to have coffee every morning and your home provider says, sorry, caffeine isn't good for you, we're not going to have caffeine in our house. Yeah, that's really not going to cut it. And having some place to take that where somebody can negotiate that for you rather than you having to worry about you're going to alienate the home providers as the individual's mom or whatever might be a useful tool for people. So the last two slides are just resources for you. And what I'd like to do is turn off the slides and then have some questions. I'm sure you have questions because this is a lot of information. And you will get the slides, so you'll have those resources. Some of them are state-sponsored, and some of them are the federal resources.
So thanks, Kirsten. Let me just give you one of the questions that was asked before in our form. So a parent has asked how to support one's child who's under state guardianship and in agency-supported housing best. So how to best support one's child?
Well, that's a very big question and a wonderful question, like so important that a family member is still being involved, right? I'm sharing this information with you because it will be leverage for you if you have a loved one in a state-run group home and that individual seems unhappy and you're trying to figure out whether that's whether you can fix that in some way. These rules might be a tool for you, right? I know that I may not be in the majority, but I'm hopeful that a lot of the changes that are coming through this 2014 rule including eventually having independent case management, may be a tool for family caregivers to be able to work with somebody who is individually advocating for your family member to address concerns where something isn't working out in a state-sponsored or provider-owned and controlled setting. Also, I think, I don't know that, I mean, I hope that this happens anyway, but your individual family member has a right to have you visit anytime, right? And that's another great way to support someone, to have eyes on what's happening.
Yeah, the second question, I think, Kirsten, you've already answered, which is
about the roommates.
Yes, about, well, whether or not there are single rooms in group homes. So I think you have answered that. So I had a question about the employment supports that you brought up. Is there still the necessity that a student in high school already have employment in order to qualify for employment supports?
Yeah, I'm thinking that while that is still written into the system of care plan, I have had several conversations with Jennifer Garabedian about the fact that this may be in violation of the rule. And it's also just not a good idea, right? I also have a concern about the possibility that there are waiting lists for employment support, at least at one agency that I'm aware of. And again, that would seem to mitigate against the idea that you have a right to pursue an employment situation if that's what you want. A 2-year waiting list, it's a question worth raising. But yes, that the technical answer is that is still in the system of care plan, and I'm hoping to have it removed.
Okay.
Barbara?
That wasn't the answer I was hoping for, but
I'm sorry. I'm so sorry. But I look forward to getting that out of the system of care plan, and I will love your help with that.
We'll be there. So Barbara, I see you. Barbara Lee, you have a question?
Hi, Kirsten. This is again about someone's rights and when exceptions can apply. I'm looking at folks who are served, Medicaid waiver, who perhaps have been involved in some sort of unsafe or violent behavior, whether to themselves or towards somebody else. And what happens to their rights under this settings rule?
So they're going to be more constrained because the exception process. So, I think one of the things we've cleaned up here is that there is a clear exception process. It's not kind of somebody just arbitrarily sort of saying, hey, I'm the home provider, and in my judgment, X, Y, and Z. But clearly for some individuals, if there are safety risks, as I said, those can be documented in the ISA. And if it requires constraining some of these rights, then that has to happen. In my mind, if the team is agreeable, a pathway toward regaining some of those rights would be an interesting thing to think about as a goal in the ISA. But again, that's a very individualized thing. So, and I can think of ways in which, right to privacy might have to be changed based on, somebody can't be safe in a room alone all night long. If I can think that the rights around visitors might need to be constrained if there are triggering individuals, or if in general that's very triggering, or there are other concerns around overnight guests or whatever. I can see reasons why people in a team might agree to constraining that. Same thing as I said around food. It will need to be clear from this that's why these SIS assessments are so important. And a lot of us are working on the supports intensity scale and how we can build that out beyond just what the form includes, to add other questions so we can tease out people's individual needs. So for example, maybe somebody's health is compromised by certain types of eating or overeating or something like that. I don't think you can completely take, like, I think it would be hard to argue that obesity by itself, for example, means that you should completely lose your right to eat anytime, unless that was absolutely compulsive. But it might mean that the team agrees to some constraints around that. And that has to be worked out individually. And remember, the individual, can then appeal that if they're like, no way, I want ice cream at 10 o'clock at night. There are actually appeal rights around that. So, but we hope that it's going to require some goodwill on the team, right? And again, having a family member involved will be incredibly important in figuring out what's best for the individual, but also honors their desires in some way. It's not really different than what we've been doing for years.
But I'm concerned that I'm thinking of if someone's rights are taken away, for X, Y, and Z reason. There isn't anything currently except for the fact that the ISA needs an annual review.
Right.
I mean, an annual review of one's rights in some cases isn't going to cut it.
I agree with you. I completely agree with you. And especially when, really significant rights are taken away. So we've talked about forensic facilities and other really constraining environments. Again, this is why this is a package, and having an independent case manager is meant as a check on that. And the ability to appeal things on behalf of an individual is part of the package here. I think that there's probably more guidance the state needs to provide. I don't think they're done yet figuring out how to implement these rules. I would agree with you that there is a concern, and there probably needs to be a cadence around how these things are evaluated that is more frequent than a year. But I don't know that the state's quite gotten there yet. So a great issue for the State Program Standing Committee to bring up. Hey, hi, Jen.
Hi, Kirsten.
How are you?
I'm feeling a little better, thank you.
Good.
I'm just curious. I know everything is so person-centered today, which I do support, as long as it doesn't impact someone's, let's say, safety and health. How do you view when, let's say, the client has guardians already assigned, family guardians assigned, or their parents assigned as guardians, their voice will be heard. And I know we can say, I just feel like sometimes there's a real pull between person-centered versus having a voice as a guardian.
Well, this goes to what actually constitutes a person-centered planning process. And again, the rule is a package, and we haven't discussed it today, but the individual has the absolute right to not only, be present at their service agreement planning sessions, at their person-centered planning sessions, but to invite anyone they want to that meeting. Now, that still assumes the individual has maybe someone who isn't a guardian in their life, but is a natural support that can advocate for them. So I can still see that there's, it's an imperfect world. There's still the possibility that someone might get themselves into a service agreement that doesn't seem supportive of their rights. But what's changing overall is A, you have to be in the meeting and you can have anyone there. And B, you have an independent case manager who only works for you, the individual with the disability. So is really there to protect your rights. And that just creates a different dynamic than in your current situation where your service coordinator has to navigate your rights, but also the home provider's rights, or the people running the group home and what they want, et cetera, et cetera. Did that help answer your question a little bit?
I guess we'll wait to see. I struggle at times feeling whether lived experience is valued for what you know about, let's say, your child.
Right.
Versus a child that can say, well, this is what I want.
Right.
And it's kind of like, okay, that kind of goes against what we know would help them to be successful, for example. So
I can tell you that I think I don't know if you've been through the support intensity scale, you know, a trial of using that tool. I'm really liking the supplemental questions that a work group I'm part of has been coming up with, because I think that they're very sensitive to the group's input around safety and success for the individual.
That's great to hear.
But I agree with you. All of this requires a lot of monitoring and advocacy. You're not wrong about that at all.
Thank you.
Can you remind us, Kirsten, what is the timeline for the independent
Yeah, I can. So the state is under a plan of correction with the absolute requirement that they stand up independent case management by, I want to say, May 2025. I'm a little unsure of the month, but I know it's 2025, which is not that far away given the amount of work that has to happen. My understanding from being on that advisory committee is that the next conversation we have to have, because I thought the first one, as you and I have discussed, was a little light, is what we actually mean by case management and what that service profile looks like versus some kind of coordination activities that would still remain with your agency. And that, I don't, as we've talked about, the state says it's going to issue these requests for proposal, but absent making those definitions, they can't have an effective request for proposal. So that needs to be the next conversation that happens. And I'm thinking that needs to start happening by January, but maybe I'm naive. But the state really, they have no choice but to have this standing up by the deadline because they're not eligible to receive Medicaid funds after that. Which, I mean, nobody wants that to happen. So I'm not worried that it will happen at all, but
just what it'll look like when it actually happens.
Right. And whether that rollout will go smoothly or not so smoothly. It's a lot of work to happen.
So until then, when you mentioned the complaint process and you had two phone numbers, the state and protection and advocacy.
Yeah.
Are there actually any forms, or do people actually have to call one of those numbers?
You have to actually call. If I am counseling people to call the state with a concern, what I suggest is that they ask to speak to the regional coordinator for developmental services. Say, I'm having trouble with my agency. I want to speak to the regional coordinator for developmental services. And I think there are 3 of them now that kind of parse out the state. That's where I would start. With legal aid, there probably is an intake form, but I believe that you fill it out verbally over the phone. Legal aid does have more capacity right now to take concerns around developmental services. They have a full-time equivalent lawyer just fielding those kinds of questions, which is not something they can sustain forever, but they have a grant to do that right now. And that'll last until September 30th of 2024. So about a year.
And again, where do we find the names of the regional coordinators?
I know one is named Melanie Feddersen. I can't come up with the other 2 names, so I apologize for that. I would ask on the phone call, but I'm sorry that I don't have them in
mind. No, it's fine. We know you don't have all the information, but it's not something that is easily found on their website then?
No, it's not actually. I agree. An org chart would be nice. for developmental services, but I'm not aware that I don't think I've ever seen one.
Okay, are there any other questions for Kirsten?
This has been very helpful to me. I am also sort of need to give this talk again, and your questions help me understand where I'm not being clear, where people have concerns. So thank you very much for all your feedback.
Okay, so thanks, Kirsten, for doing this workshop. For everyone else, you'll see that we have a link to the evaluation in the chat, and we ask you to please take a few minutes to fill it out so we can make improvements as well as fulfill grant requirements. So we have many more interesting workshops coming up, and you can find details on those on our website, vermontfamilynetwork.org, along with the links to the previously recorded ones. We have tons of information on our website. Getting connected to us is easy. You can follow us, VFN, on Facebook or join one of our closed Facebook pages if you are a parent. You can also sign up for monthly e-news or check out our YouTube channel. So we are here to help. Thank you, everyone, and have a great day.
Thanks, everybody. Have a good day. Bye-bye.
Thank you.